Bridget Welsh is an independent scholar and political analyst currently based in Kuala Lumpur. She is currently an honorary research associate with the University of Nottingham Asia Research Institute, Malaysia. She is also a senior research associate of the Hu Feng Center for East Asia Democratic Studies of National Taiwan University and a senior associate fellow of the Habibie Center. She specializes in Southeast Asian politics with focus on Malaysia, Myanmar, Singapore, and Indonesia. An author and editor of numerous books, reports, and articles. The latest book is Sabah from the Ground, 2020 Elections and Politics of Survival, was published in May last year. Our third panelist is YB Chong Chen Jen, is the current MP for Stampin and is a practicing lawyer at the legal firm Mrs. Chong Brothers Advocates. He graduated with the degree of Bachelor of Commerce, Accounting and Economics, and Bachelor of Law from the Australian National University, and was admitted as a legal practitioner of the Supreme Court of New South Wales in February 1996. He has served as the Deputy Minister of Domestic Trade and Consumer Affairs from July 2018 to February 2020, and has been elected as a member of the Malaysian Parliament since 2004. He has also been elected as the current State Assemblyman for Padungan in the recent Sarawak election in December 2021. And our fourth panelist is Datuk Sri Panglima Wilfred Madius Tangau, a member of Parliament for Tuaran and the President of ARCO. He is also the former Deputy Chief Minister of Sabah and also a former Federal Minister of Science, Technology and Innovation. I would first like to invite our first speaker tonight, Professor Shad Salim Faruqi. And I believe, Professor Shad, you're very well aware of the recent amendment to our Constitution, particularly in regards to Article 1 Sub 2, Article 160 Sub 2, and Article 161A of the Federal Constitution. And can you explain what is the significance of the approved Constitution amendments that seek to restore Sabah and Sarawak's position as equal partners in the Federation with the Peninsula States? And I believe, Professor Shad, you have prepared some slides, and I think we have already got your slides, and we will assist in giving the slides in your presentation. Yeah, thank you. So without further ado, Professor Shad, the floor is yours. Thank you. You need to unmute first, Professor. Unmute first. Thank you.
Right. Thank you very much, Mr. Chairman, Nelson Angang. It's my privilege to be on this distinguished panel. Oh my God, Daddy. I wish you all Salam Sejahtera, Kopi Bosian, and Pak Kabar Kita. Now, the gist of what I have to submit to you is this, that the Constitutional Amendment Act 2021 has 4 provisions, 2 of which are very important. The first one of which is very significant. This is the new definition of the term federation to include the federation established under the Malaysia Agreement of 1963. The significance of this amendment is that it constitutionalizes the MA1963, which up to now was merely an international agreement without the status of law. A second notable change is Article 1, Clause 2, which defines the territories of Malaysia and places the states of Malaya and the Borneo states in separate categories. Now, in my view, Mr. Chairman, this is more symbolic than substantial, but it indirectly reaffirms that Sabah Sarawak are a special and autonomous class, and that our federation is not a federation of equal states, but is asymmetrical. May I go to slide number 4?
This shit is mad boring.
A third aspect of the amendment is that it deletes the federal definition of who is indigenous to Sarawak and thereby qualifies as a native. The power to determine who is indigenous, who is a native is now rightly assigned to the legislature of the state. I was a little bit surprised that this amendment is only about Sarawak, but did not touch on the status of natives in Sabah. I would have hoped that both the states were given equal freedom on this. A fourth aspect of the amendment is that the term Malaysia Day is inserted into the lexicon of the Constitution. May I go to the next slide, number 5? The amendment of Article 1, Clause 2. This amendment reverts to the constitutional position of 1963, when the territories of the Federation were described in 3 separate categories. Now, though widely applauded, this amendment, in my view, is primarily symbolic, as it confers no additional powers or rights. However, it has significance because it indirectly recognizes that Sabah and Sarawak are special and have a different autonomous and asymmetrical position in the federal setup of Malaysia, something that was clearly envisaged by the Intergovernmental Committee report of 1962.
This shit is mad boring. I'm sorry, Prof. Shad, but this shit is so fucking boring.
Yo, facts, bro.
Mr. Chairman, I'm not so sure what's that about.
Yes, I apologize for that. I think can the technical team just look into it? And I think there is some issues.
I see. Okay.
Yeah.
But
apologize, Professor. Just continue, Professor.
Yeah.
Thank you.
So this special asymmetrical position was clearly envisaged in the Malaysia Act 1963, and before that the IGC of 1962.
Oh my God.
And the significantly amended Federal Constitution of September 1963. Next slide, number 6. Note, however, that the amendment does not and cannot satisfy the popular assertion, which Mr. Chairman talked about, that Sabah and Sarawak are now equal partners in the Federation in the equal partners to the Federation in the Peninsula States. The amendment nowhere divides the country into 2 equal regions of the Malay states and the Borneo states. It is noteworthy that in some executive, legislative, judicial, and financial areas, Sabah and Sarawak are not equal, but more than equal, and enjoy autonomy and special powers that are not assigned to the Peninsula states. In fact, in some areas, equality will be a downgrade. Then from the point of view of legal personality, Mr. Chairman, there is no separate legal entity called Peninsula States and Borneo States. Sabah and Sarawak and the 11 Peninsula States have their own separate constitutions. And along with the 3 federal territories, each entity has its own juristic personality. Next slide. In some areas, Sabah and Sarawak, in fact, suffer disadvantages compared to the Peninsula States. For example, Malaysia's head of state, the Yang di-Pertuan is by law always from the Peninsula. In the King's election or dismissal, the governors of Sabah, Sarawak, Malacca, Penang have no role. In the Dewan Rakyat, Sabah, Sarawak have 56 out of 222 MPs. West Malaysia has 166 out of 222 MPs. In the Senate, out of 70 senators, Sabah, Sarawak has only 4. West Malaysia has 22, and there are 44 appointed senators. Next one. In the annual budget allocation, so this is a point to be covered later on, Sabah, Sarawak, slide number 8, please. Sabah, Sarawak do not receive 50% of the allocations. Perhaps they should, but no law requires that. For example, it is reported that in the 2022 budget, Sabah and Sarawak together received 9.8 billion development allocation compared to the peninsula's 67.8 billion. This amounts to actually 12.6% of the development budget. So the popular notion of equal partners with Malaya is not based on any law or any historical document either. In many areas, Sabah and Sarawak are more equal. In others, they face serious disadvantages. Next slide, 9. Now the definition of the term federation. Article 160, Clause 2 is amended to
So
redefine...
160 is amended to redefine the term federation.
Article 160, Clause 2 is amended to redefine the term the federation. The definition prior to the amendment was that the federation means the federation established in 1957. The new definition rightly acknowledges, though 58 years out of time, both the 1957 and the 1963 federation. It specifically mentions the new federation pursuant to the agreement of 1963. To me, that is very significant. There is incorporation of MA63. The reference to the Malaysia agreement in the constitutional amendment is significant because it amounts to incorporation of MA63 into our constitution. Next slide. Along with MA63, let me explain that. MA63's constitutionalization is important because in our legal system, international treaties, agreements, covenants signed by the executive are not enforceable locally unless given the kiss of life by Parliament. Up to now, MA63 and the Intergovernmental Committee report, the 20 points, the 18 points were basically international agreements or international documents. They were not enforceable in local courts. But now MA63 is upgraded to constitutional status by our Parliament. Next slide, 11. Along with MA63, the IGC report of 1962, it was actually signed in 63, but 62 is also constitutionalized. And I take note that MA63 specifically says the government of the Federation of Malaya, North Borneo, Sarawak will take such legislative, executive, or other actions as may be required to implement the assurances, undertakings, and recommendations contained in Chapter 3 and Annexures A and B to the report of the Intergovernmental Committee. Next slide, 12. The IGC report has 37 sections and 4 annexes and is rich with legal, political, and financial provisions, which must now, in my view, be taken note of as legal rules. Next slide. Some of the issues mentioned in the IGC were never incorporated into the Constitution of 1963. I have given some examples. 4.1, Section 26, Clause 4 of the IGC report states that when the Supreme Court, as the federal court was called then, when the court hears a case arising in a Borneo state, at least one judge should be with Bornean judicial experience. This IGC prescription was rejected as having no force of law in 2 cases. And I think both these cases now need review. Next slide. 4.2, 40% of net revenue derived from Sabah must be given back to Sabah. Another provision not fully enforced in the Federal Constitution's Article 112C and the 10th schedule is that there should be special grants for Sabah Sarawak. Specifically in the case of Sabah, Sabah is supposed to receive 40% of the net revenue in excess of the 1963 revenue derived from the Federation from Sabah. Next slide. Research by one of the University of Malaya master student, Mazliani Muhammad Lan, reveals that in the 1964 estimates and revenue expenditure, there was a precise mention of the 40% grant allocation to Sabah. However, regrettably, from 1969 onwards, such mention is no longer evident. May I go to slide 17? Election Commission. Article 114 provides for the composition of the Election Commission. Paragraph 25 of the IGC report requires that one member of the Election Commission shall be from Sabah Sarawak. But sadly, that's not provided in Article 114, Clause 1. Next slide, 18. The term Borneo States was repealed from the Federal Constitution in 1976. I hope that it will now be reinstated due to the 2021 amendment, which specifically uses the word Borneo States. So all in all, it appears to me that with the passage of 2021 amendment, the provisions of MA63, the IGC report, and the vocabulary of Borneo States have been constitutionalized. A new judicial approach is needed to the interpretation of our Perlembagaan Persekutuan. The existing provisions must be interpreted as far as possible in harmony with these historical documents, which are now constitutionalized. May I go to slide 21? I'm just about to finish, Mr. Chairman. In my view, there is a good first step. Is the amendment a good first step, or is it mere symbolism? Autonomy and special rights of the Borneo States are contained in about 80 or so provisions of the federal constitution. They're already there. And these need to be revived and enforced both in letter and in spirit. The amendment to Article 1, Clause 2, however, is more symbolic than substantial and will not be the magic wand to resolve many woes that need additional measures. The list of litanies, complaints that need attending, is long and painful. Next slide, 22. There is discontent about the inequitable sharing of resources and lack of what is called fiscal federalism. Sabah and Sarawak constitute 60% of the territorial surface of Malaysia, but receive a meager proportion of the federal budget. A major complaint is the meager 5% oil royalties. Next slide, 23. The mandatory allocations have not been assigned to Sabah Sarawak. Next slide, 24. Despite their abundant natural resources and massive contribution to the national coffers, Sabah and Sarawak rank amongst the poorest states in Malaysia and lag behind in infrastructure, etc. Next slide, 25. Amendments to the Federal Constitution. Article 161, Clause E, specifically says that some amendments which affect the rights of Sabah Sarawak must obtain the consent of the two states. Now, in the last 58 years, in some cases, amendments were proposed, and for reasons I do not understand, Sabah Sarawak MPs did not object, and these amendments went through. For example, Labuan was federalized. In other cases, however, consent was not obtained. For example, Article 121, Clause 1 was amended in 1988 to emasculate the powers of the High Court. High Court includes the High Court of Borneo, and I think the consent of the governor must have been obtained, was not obtained. The power of the governors to appoint judicial commissioners was transferred to the Yang di Pertuan Agong in 1994. Issue was raised in Robert Lingi, but it failed in the federal court. Next slide, 26. Borneoization of the administrative services is producing too slowly. Then Sabah Sarawak's rights over immigration has been violated because of the naturalization of thousands, if not millions, of illegal immigrants. Slide number 27, Islamization. The moves towards an Islamic state, the plan to introduce hudud laws, the attempt to export the peninsula's hardline Islamic trend aroused discomfort in Sabah and Sarawak. Laws have been enacted to provide that in the case of Muslims, native law will not apply and the Sharia court shall have compulsory jurisdiction. Now, this contrasts with the practice in the peninsular states where Sharia courts enforce both custom as well as the Sharia. Now, next slide. Federal control over politics. Despite the autonomy of the states in many prescribed areas, the federal government controls the political and administrative processes in these two states. Slide 29, representation in the Dewan Rakyat. Sabah, Sarawak do not anymore have the 33% representation envisaged for Sabah, Sarawak, and Singapore in 1963 in order to give these states protection against constitutional amendments which require 2/3 majority. When it comes to federal appointments, despite Article 153, which puts the natives of Sabah, Sarawak on par with the Malays of Peninsular Malaysia, Sabah and Sarawak are seriously underrepresented in the federal public services. May I go to slide number 31, the second last slide. Hopefully, most of the above complaints, there are actually many others, will get a proper hearing and a fairer resolution soon. By way of conclusion, what I wish to say, slide number 32, both as a matter of expediency as well as a matter of fidelity to the provisions of our 1957 and 1963 Constitution, the political leaders of West Malaysia must rebuild bridges of understanding with our brethren across the South China Sea so that this federation can grow stronger. This amendment bill gives some hope. It's also noteworthy, last slide, slide 33, it's also noteworthy that the new political realities since the 2008, 2013, 2018 general elections indicate a rising influence of our East Malaysian states. Governments in Sabah, Sarawak must seize the moment and work with the federal administration to adopt and practice new national and state policies also on sustainable development, education, and elimination of poverty in Sabah and Sarawak. Thank you very much.
Thank you. Thank you so much, Professor. It's a very interesting view that you have given in respect of the amendment, especially in respect of the amendment on the definition of the federation, where you have actually said that it has given the keys of legal life of MA63, giving it a constitutional, basically part of the constitution. Because there are some view, you are correct also, there are some view that the amendment in respect of Article 1(1) is seen as merely symbolic. So, but because of how you actually put it, how you shared, how you actually give your opinion in respect of 160 is something that is very interesting. And I think I will go back on that later. There's some question. But the next, I would like to pose this question to Dr. Bridget first. We have heard what the opinion by Professor Shad in respect of these amendments. What is your view in respect of the significance of these amendments in terms of politics in Sabah and Sarawak? Because as we all know and aware, the issue of MA63 is one of the issues that has always been hotly debated in Sabah and Sarawak, even since the formation of Malaysia. So now with this amendment and with the definition that is given by Professor Shad, his opinion that it now gives a legal life to MA63, but what is the impact that it would bring to Sabah and Sarawak? Yes, Dr. Bridget, thank you.
Thank you very much for an opportunity to speak, and also it is always a pleasure to listen to Prof. Shad in terms of his richness of the discussions and the legal discussions. Let me begin by saying that there are many things that I share in terms of the perspective of Prof. Shad, and that I do believe that this particular amendment has very serious gaps, but I do think it also it is part of an ongoing process that begins to point to a greater representation and greater rights for Sabah and Sarawak. My concerns, however, politically, is that from the perspective of Peninsular Malaysia, the amendment is seen as an end as opposed to a beginning. And I think this is very much, in terms of the substance, necessary to actually see this as a beginning process, a continuation of amendments that need to be changed, but also more fundamental shifts that need to take place in the power relationship, in the decentralization relationship between Peninsular Malaysia and Sabah and Sarawak. In terms of looking at the amendment itself, from my observation, we can see that this process is one of appeasing the power of state nationalism, which has gained traction. It's not just about elite representation at the national level, but what we do see are growing sentiments for secession and considerable unanimity across political perspectives, both in Sabah and Sarawak, for greater representation. And I think the Peninsula Malaysia leaders and in this amendment have acknowledged that. Of course, the amendment was put forward by a Sarawakian, but nevertheless, it was passed. I think, however, these, as I've mentioned, this is still very much from their perspective appeasement, as opposed to really fundamentally recognizing the need for changing the relationship. We see a situation where many of the core issues involving Sabah and Sarawak have not been mentioned in terms of transparency, the RCIs, the documents and issues over the 20 points. All of these issues are still very much at the elite level. One of the problems with this amendment is that the conversation is very much legalistic and not necessarily in terms of dealing with the substantive issues. And this is one of the bigger challenges of Malaysian politics right now, is that the reforms that are ongoing have very little impact on the ground for ordinary people. So for many Sabahans and Sarawakians, this particular constitutional amendment has very limited implications. And in this regard, from the perspective of the amendment as a whole, I see this as not a solution, but part of an ongoing process towards solutions of existing problems. I want to pick up a little bit also on what Prof. Shad said about the issues and the problems in the relationship, the levels of grievances. I think that, to conceptualize this amendment as about equal partnerships is actually fundamentally flawed. Until the grievances have been addressed meaningfully in terms of development, in terms of infrastructure, social services, health and education, the issues of resources in terms of revenue, the access to the economy, and more generally for Sabahans and Sarawakians, and cultural rights, you're going to have very significant problems that are going to fester. And this bill, in my view, does not begin to do these things in meaningful ways. And so it is now up to the leaders in Sabah and Sarawak, and as the discourse of civil society, to give more substance to the constitutional amendment through a discussion and to carve out political space about these particular areas. And I'm hoping in some ways this conversation allows that that the measurements of equality begin to take shape in a more meaningful way. I would like to sort of close my remarks by saying that I think that, the amendment talks about the idea of partnership, but I do believe in looking at the political environment, there still remains very serious problems in the nature of partnership. I think many people in Peninsula Malaysia continue to have a lack of understanding and a lack of respect for Sabah and Sarawak. Measures are made very in a temporal way, as opposed to more significantly, substantively, and over time in a meaningful way. The relationships are still very much with the elites. And of course, there are challenges of the elites within Sabah and Sarawak as well, in terms of patronage and resources and corruption and others that do not address the meaningful dimensions of the people on the ground. And as a consequence, what's happening is that the partnership is a very shallow partnership. And it is also one not vested on a sense of genuine equality and respect. And I think right now there needs to be more conversations, especially with people in Peninsula Malaysia, about some of the real challenges on the ground and how to transform the relationship in a more meaningful way that also creates new types of partnerships beyond the elite level. So let me stop there in terms of my remarks. I wanted to keep them brief and a bit provocative in saying that there is clearly a lot more needs to be done.
Thank you, Bridget. Yes, we will get back to you on that. In respect of yes, it is only your view is that the amendment seems to be as a method of appeasement only, and there's a lot of other things that needed to be done. Then I will go straight to the third panelist tonight. I would like to invite Dr. YB Chong, YB Chong Sin Jen. Recently, when the amendment was introduced in Parliament, I believe YB Chong and YB DSP Madius Tangau has actually submitted a motion to the Speaker to incorporate an amendment to the 9th schedule of the Federal Constitution in respect of to devolve power over healthcare and education. However, the motion was rejected by the Speaker. And after having heard the opinion from Professor Shad tonight, that the amendment in respect of the meaning of the Federation of Malaysia gave a legal life to MA63. So there are some views that the current amendment, even in the amendment of the interpretation of the Federation of Malaysia, does not legally show any change in the decision-making powers under Sabah and Sarawak. How would, in your view, YB, how would this amendment affect the restoration of Sabah and Sarawak rights if it is not followed by a decentralization of power? For example, like the motion that you have submitted in respect of education and health. Yes.
Thank you. Good evening, everyone, and thanks for the invitation to this webinar. And in respect of the constitutional amendment that was tabled last year, yeah, that the worry of that we had was very well put by Professor Bridget Welsh. That it may be deemed as an end to the whole restoration of MA63. That is why we have put in myself and YB Wilfred has put in the amendment to the amendment, the motion to amend the amendment by incorporating our proposed amendment that is the power on education and healthcare, and to include it into the concurrent list. As you know, I mean, in terms of the last amendment that was passed in the Parliament is more informed. An amendment talking about restoration of the rights of the respective regions pursuant to the MA63. Basically, that amendment was more informed than in substance. But as far as the power of the states and power of the federal government, it is listed in the 9th schedule of the Constitution, which provide the list of federal list of power, state list of power, and state list of power specific to Sabah and Sarawak, and the concurrent list. Right. So far, I mean, for what we have proposed actually is that, you know, the amendment to start with, it should also include the amendment to the concurrent jurisdiction of both the state and the both the Sabah and Sarawak and the Federation. That is under list 3, specific to Sabah and Sarawak. So that is why we put in the amendment. Why we put that in? Because we see that this amendment that was passed in December came about almost 2 years too late. It was first proposed by the Pakatan Harapan government that the definition of Malaysia, the Federation, be restored to the exact form when we formed Malaysia. But that our proposed amendment was rejected in the parliament, and now in December, here comes the amendment to that to the federal to the constitution, restoring the definition of the federation to what was in form of in our 1963 constitution. That I see as a first step, and we are concerned that, you know, it will be deemed as the end of the whole struggle rather than the beginning of the whole struggle, not only by the federal side, but also even by the state. So I think now that as you all are aware that Sarawak has gone through an election, and that the GPS has won big time, and there may be some silver lining in that result, in that now that the GPS is given the greater power to govern the state. I think what should be done, I think, to ensure that, you know, the decentralization of power, and that to balance or to make good what has been done, the injustice done to Sabah and Sarawak all this year, or in particular Sarawak all these years. I think there must be a timeline set by the state government in terms of devolution of power, in terms of the allocation, a fairer allocation, how it should be increased proportionally for Sarawak. I think all these are the concern of the Sarawakians now, that, you know, since that after the election, the GPS has won bigger representation in this in the Dun, then there must be a timeline stated for the next 5 years. For the next 5 years, that, you know, when we should achieve devolution of power in education, when we should achieve devolution of power in healthcare, and how should the allocation for Sarawak be increased proportionally every year, so to achieve to make good what has been done, what injustice has been done to us, Sarawak here, in terms of the disproportionate allocation of fund all these years, and to address the issue of the representation in Parliament, Sabah and Sarawak representation in Parliament. One way of addressing that imbalance representation could be done through the appointment of senatorship. I think in all federation there is this question of one person, one vote, the value of one person, one vote, and surely under such a system, I believe that, you know, the states that has the greater population would naturally have a greater representation in the Dewan Rakyat. The whole thing is that in the Westminster system, there's always this the senator level in the parliament to safeguard those states which are underpopulated. And in that sense, I would believe that, you know, a quick way to address this underrepresentation in parliament could be immediately done, or could be in a short time rectified by increasing the number of senators to be appointed by the states proportionally vis-a-vis the West Malaysian Peninsula state and Sabah. So I think that can be a quick way to address that underrepresentation in Parliament, and also to safeguard the interests of the state. And after all, I think the system of senator is to safeguard the interests of the states which are underpopulated, and that is the case of Sabah and Sarawak compared to Semenanjung. I think so. For now, I think I'll just in short, there are a few things that I would like to stress is that I think there should be a timeline set by the current state government in terms of rectifying what has been wrong, the wrong done and injustice done to Sabah and Sarawak this year, and that timeline must be specified clearly and for the next 5 years. And number two, and that will include devolution of power, decentralization of power, and also the unequal, unfair, or inequitable allocation of fund for in respect of the three regions. And that's all I think for now. My piece, I'll say my piece, and then I'll pass it back to the moderator.
Thank you, YB. Yes, for now, we will take some questions later from the participants. Okay, for the fourth panelist, Yang Berhormat, Datuk Sri Panglima, Madius. Now that the amendment has been made, some say that we are now equal partners. Professor Shad has a different view in respect of us being equal partners. My question to you, sir, is that do you believe that it is important for Sabah and Sarawak to be seen as equal partners in the need to accelerate the much needed infrastructure and economic development for Sabah and Sarawak? Yes, sir.
Thank you, Nelson. Yeah, this particular amendment actually raises a lot of hopes, particularly Sabah and Sarawak, since the announcement by the then Prime Minister Tun Mahathir during the Malaysia Day of 2018, that and he specifically mentioned that they will undertake to restore the equal partnership of Sabah, Sarawak, and the Peninsula. Yeah. But clearly, as mentioned by Professor Saad, that is more of symbolism rather than in reality. Yeah, but there are several things that can be done, and Bridget pointed it out rightly that it is very important that this process of that amendment and constitutionalizing the MA63 must not end here. It is actually a new beginning, a new beginning, and it is very important to raise the awareness, particularly among leaders in the peninsula, including the civil service. Yeah, that on two areas. First is the question, the issue of decentralization. Okay, whatever it means about whether we are equal partners or things like that, but this issue of decentralization must be undertaken. Give you an example on the 40% net revenue to Sabah. Okay, the 2018 election presented an opportunity for Malaysia to actually implement this, because the ruling party, the government then, not only made it as the election manifesto, but they were actually there in position to do it, but eventually they couldn't. Why? Because they are not actually in control. The civil service, the civil servant are in a stronger position, whether to do or not to do. For example, the Majlis Keuangan Negara. Okay, the Majlis Keuangan Negara will decide whether or not they will give this 40% to Sabah. This is unique to Sabah. It's not to Sarawak, but to Sabah. Okay, it is our entitlement, but why are not they giving it? I would imagine a civil servant sitting there in the council, in the financial council, to say that why should we give this to Sabah? although it's an entitlement, why should we give this? All right. So perhaps one way to address this, other than, for them to recognize that this is an entitlement, it is agreed upon in the agreement 1963. Yeah. But the other one is the administrative side, and by looking at it, by going through the decentralization. So for example, okay, it's 40% to Sabah. We could agree, for instance, I could support Selangor to have, let's say, 10% of the net revenue, or Negeri-9, or even perhaps Sarawak, things like that. And we can give it to you. Maybe the civil servants say it more, it's easier for them to say that, yeah, I'll be also getting something. But for Sabah, 40%, it is in the agreement, it should be given. Okay, so that's one form of decentralization. Of course, the other thing is, as I and YB Chong have presented the motion to amend the Schedule 9 on the concurrent list, yeah, to make the education and health as a concurrent list, so that the state, Sabah and Sarawak, or even other states could participate and undertake to implement some of this. And this is particularly important for Sabah and Sarawak because under the local government ordinance, a local government, a district council could actually undertake educational matters. It is in the subsidiary laws, it's in the ordinance, including even agriculture, things like that. But it has never been implemented. Small repair of schools and things like that can be undertaken. Majlis Daerah could spend money for education, things like that. But since education is a federal matter, so even the state government or local government have conveniently given it to the federal government, and if ever they want to go into this on educational matters, infrastructure, things like that, they will ask, is the allocation, is the federal government giving allocation or things like that, And to me, when you go into dilapidated schools in the state, in Sabah, the state government should be allowed to contribute to this. Local government should be able to contribute to this and things like that, yeah. And I would imagine that under a situation where we actually secure the 40% net revenue to Sabah, we'll be able to contribute more to this, okay. Other situation, like for example, which I could cite, rancangan makanan tambahan. Right now, it's only 3 ringgit per person per meal. 3 ringgit at this time. It doesn't make sense. And a lot of pengandali, contractors out there, they can hardly, I think many of them are refusing to implement it because it doesn't make sense anymore. But if the state government or a local government could contribute to the 3 ringgit per student per meal and make it, let's say, 5 ringgit or even 10 ringgit or things like that, then it will make sense. So that is one form of decentralization that is important that I could say. The other part that is very significant, I have said this before and I have said it several times, is pertaining to the IGC. I've said about the need to have IGC 2.0. We need to review it. So tonight, when this is actually something new even for me, from Professor Sad, that you have now, through this amendment, you have now constitutionalized the IGC. I think this is very pertinent. But for the IGC to be really, really implemented, I think we need a review. So if all this while we talk about a review of the MA63, I think in actual terms, in actual terms, a review of the IGC, I think is much more important. There are various things. I mean, I'm shocked to see tonight that some litigation in the past went through saying that the IGC is not a legal document, and of course it has given a totally different outcome. Yeah, so we should conduct. And now that we have unit Sabah and Sarawak in the Prime Minister's Department under Dr. Max, I think he should undertake this. He should really undertake this. Even the decentralization that I mentioned earlier, that unit should undertake this, and there should be a proper council, a federal state council, because it should not just be Sabah and Sarawak. It should involve all the states, because each states have their own peculiar federal-state relation. They have their own issues and things like that, and that should be addressed. Yeah. We have our own peculiar issue, Sabah and Sarawak. 40% is only for Sabah; it's not for other states. But to implement it, I think it will take the agreement. It will take the support of all the other states. Yeah. Okay. On the issues of the representation in Parliament, yeah, 35%. Of the House of Representatives are supposed to be from Sabah, Sarawak, and things like that, or rather from outside the peninsula. But obviously, it is no longer, doesn't stand it anymore, and it's not easy to create a new constituency. It's very, very difficult. Yeah, but it is easier, perhaps, to increase the number of senators from Sabah and Sarawak. Yeah, I think it is doable. It's easier to do it, yeah. And all it takes is just a simple amendment to the federal constitution and specify the number of from Sabah and Sarawak, because right now it doesn't make sense. There are more senators from the federal territories than from Sabah and Sarawak. Yeah, and all we have is the senators that are appointed by the respective state assemblies. So this is under areas of decentralization, and I will see this as something that will strengthen the federation, will strengthen Malaysia. It will address some of these issues on we call unhappiness from Sabah and Sarawak, and in the process, we would achieve what Professor Saad talked about, sustainable development, and address pressing issues like poverty in Sabah Sarawak, particularly in Sabah. Thank you, Nelson.
Thank you, DSP. Okay, I have okay. After this, we will be taking questions from the public. We have some questions already in Zoom and in FB. But before we proceed with that, I have one question for Professor Shad, because of the view that you have given. It is something that is quite interesting, because as I said, there is a lot of opinion out there saying that the amendment to Article 1.2 is merely symbolic. But you have given your view, sir, that the amendment on the definition of the federation itself has already given the legal life on the MA63, and I believe you also mentioned on the IGC report, it has also given some legal life to it. So my question, Professor, is that in one of your slides, you mentioned that there are about 80 or so provisions in the federal constitution, and all these provisions need to be resurrected and enforced, both in letter and spirit. Now, my question is this: how would the state, Sabah and Sarawak, be able to ensure that these 80 or so provisions in the federal constitution can be resurrected and enforced in the event, for example, in the event that the federal government, for example, is still slow in fulfilling this? Is there any legal ways of both states to enforce their rights? Maybe Article 8 of the MA63 in mind? Yeah, thank you, Professor. Yes.
Yeah, actually, when Sabah Sarawak federated with the Federation of Malaya, one of the very clear terms was that Sabah Sarawak must have some special terms. For example, the issue of Borneoization, the issue of immigration, on the issue of Islam. It is not very well known, but actually the Constitution in 63 said that if any law is passed to restrict the propagation of a religion to Muslims, that law cannot apply to Sabah Sarawak unless 2/3 majority is obtained in the State Assembly. A law also said that if federal money is spent to promote Islam, an equivalent amount should be allocated for social purposes in Sabah Sarawak. And there are actually other provisions relating to Islam. Many of them were repealed in 1976. So the Constitution in 1957 did try to give to Sabah Sarawak a special position. I use the word asymmetrical. Sabah Sarawak are not equal to each of the 11 states. It's much more than equal. Sadly, things have not worked out. For example, simple issue would be Article 153 on the special position of the Malays and the natives of Sabah Sarawak applies to both. And yet, actually, you can see that in the federal government departments, in the ministries, in the universities, in statutory bodies, it is quite clear there are very few senior people from Sabah Sarawak. So your question, Mr. Chairman, your learned question is, how should we achieve that? I personally think part of the problem is lack of legal literacy. Dato Sri Panglima Wilfred Medi has pointed out, civil servants just don't believe in the special rights of Sabah Sarawak. Maybe they have not read the Constitution. So I think we need to undertake a thorough study of the federal Constitution. We need to promote constitutional literacy. The provisions of MA63 and IGC, many of them were adopted in the Constitution. Some of them have not been implemented properly. I gave an example, let's say, of special position of the natives of Sabah Sarawak. So this is a political and administrative issue, Mr. Chairman. The governments of Sabah Sarawak and pressure groups, they need to assert themselves and say, it's in the Constitution. So that's one. What is already in the Constitution is not being implemented. Secondly, there are issues where provisions were not included. For example, the issue of Borneo experience. That provision is there in the Intergovernmental Committee, but it's not in the Constitution. I think we need to pressurize the federal government to include those provisions, because MA63, which is now recognized, says very clearly that the federal government shall ensure that these provisions be employed. Now, in my personal view, federal government doesn't only refer to executive, it refers to all organs of the federal government, judiciary, legislature, and the executive. And thirdly, Mr. Chairman, there are some provisions which were repealed. They need to be restored. And it will take a long time actually, but there are some provisions. I can give just one example. 3 provisions on Islam were repealed from the Constitution. They need to be restored. Thank you.
Thank you, Professor Shad.
Thank you.
Yes. I would like now to invite Dr. Bridget. I have a question. The question is that since the view now, the view that there are about 80 over provisions in the federal constitution that needed to be resurrected, as Professor Shad said, do you foresee that the government of Sabah and Sarawak have the do you believe that these 2 state government will have the how to say this, they would be able to enforce this right in respect against the federal government? Do you foresee that they are willing, to put their foot down, for example, to enforce all the provision in respect of the rights for Sabah and Sarawak after this amendment. And to the extent, as I believe Article 8 of the Malaysia Agreement states that, I believe even to the extent, since Professor Shad said now they have this MA63 is a legal document now, and the court can actually look into it and make decision. Do you foresee that these two state governments are willing to go to that extent of bringing it to our courts to enforce our rights politically, the state government of Sabah and Sarawak against the federal government, of ensuring and enforcing the rights in MA63?
Thanks very much for your question. I just want to speak up first on what Prof. Shad was saying about the need for literacy. He talked about legal literacy. I would like to stress that it needs to go well beyond that. I think that in Peninsular Malaysia, there is a lack of understanding of Sabah and Sarawak. The history books leave out the stories of Sabah and Sarawak. And these things need to change because you have to get a more holistic understanding of all parts of Malaysia and give due respect to the history and the cultural diversity of Sabah and Sarawak within the context of Malaysia. And that, I think, is something that needs a more holistic approach. So literacy beyond legal literacy and education and understanding need to move forward. Now to the questions about the state government of Sabah and Sarawak. First of all, I think it's very important to acknowledge that Sabah and Sarawak have very different experiences from each other. And there is a tendency to equate these two territories, two areas, two states. We always, the words are carefully used here, in a similar. And I think they have different sets of issues and different dynamics within their communities that I also think need to be acknowledged. The relationship between Sabah and Sarawak is not as there's not as cordial a relationship that could be because there are, and I think this is something that is not often talked about. And I think in particular, while they share similar issues, there are different particular challenges that some of the states face. In particular, Sabah is facing the issue of dealing with the challenges of undocumented persons. And in particular, I think that is an issue that needs resolution in some sort of movement. Now, to the question of the state governments, I think that they are going to lose an opportunity if they do not act after, and to begin to consider that this is an opening, an opportunity to address the concerns of their citizens, and also the fact that they have tried both in Sabah and in Sarawak, particularly in Sarawak, they have used issues of state rights as a form of legitimation for themselves. So, and they will also, if they fail to act, they will erode some of the legitimacy that they have tried to build in a meaningful way. But I see much more resistance to taking measures in Sabah than they do in Sarawak. And I think this is part of why I point to the differences. We've seen more meaningful measures towards decentralization and engaging legally in Sarawak compared to Sabah. And I think there are particular issues in the federal-state relationship with Sabah that make that more challenging for many of the Sabah political leaders. But I think there is now, as I mentioned earlier, this is an opportunity. The amendment provides an opportunity for traction. And I think a failure to act will mean that this will actually be a much more backward motions, because the opportunities will be lost. The window for change will be lost. And so I think, when there is a conversation that is not bogged down in partisanship, but among Sabah leaders, among Sarawakian leaders about what to do, I think those conversations really need to take traction. And I hope these conversations today help to address some of those issues in a meaningful way, to encourage more proactive measures. Because I think that the worry is that both in Sabah and Sarawak, they see the amendment as an end as well, not necessarily a beginning.
Thank you, Doctor. Thank you. I'm going to take a few questions from the public now. I'm going to pose this question to YB Chong and perhaps Professor Shad also, because this is a legal question actually. This is from Yu Zi Yo. Sorry. Okay, this is the question. Regardless of whether Sabah and Sarawak have the ability to become states, my question is whether Sabah and Sarawak have the right and freedom to secede from the Federation of Malaysia. If so, is it illegal or unconstitutional? If not, can they be granted that privilege? Thank you. And another question, I'll take another question from CMT. Is Malaysia a newly formed nation, or is it merely the enlarged or Federation of Malaya with the name changed slightly? So there are two questions there. The first question is in regards to whether Sabah and Sarawak has the right to succeed. And I believe maybe in the second question is, I think this is in terms of the amendment on the definition. You know, there's always this debate that that Malaysia is a new federation, but there is also the view that Malaysia is actually an expansion of an existing federation. So I will first ask YB Chong in respect of the succession question, because I believe this is one of the issue that was played out in the recent Sarawak.
Yeah, that's right. Yeah. Well,
YB Chong can give a view on
the
this.
right of secession. I think if we look at the ICG report, intergovernmental report, I think there is a provision that there shall not be any right of secession.
20-point agreement.
Yeah, that's right. In the agreement, there's a provision clearly stated there shall not be any right of secession. But having said that, I think in any federation or for any constitution of a country, it is not a static document. Right? A constitution of a country is not a static document. Right? The whole thing, it goes, the same applies to when Singapore is part of Malaysia. And when the circumstances are there that require cessation or separation, then it happens. So what happens is that, when I said that no constitution is a static document, it means that the constitution can be amended with a 2/3 majority in the parliament. And if in one day in the future that 2/3 majority of the members of the parliament agrees that Sarawak should and West Malaysia and Sabah should go different way, I mean they voted in the parliament, then it becomes a reality. So if you ask me whether there is any right of secession, it is not provided in the constitution. And now, as Prof has said, that the 20-point agreement has been constitutionalized, then that is the constitutional provision that there shall not be any right of secession. But the constitution can be amended with 2/3 majority. So anything is possible, right? It depends on the political situation and the wishes of the people of Malaysia. That is my answer to the first question. And the second question, whether is the Sabah Sarawak is an extension of the federation, or together with Malaysia it forms a new federation. I believe I subscribe to the second interpretation that Malaysia is a new federation. It is not an extension of the Federation of Malaya, by the mere fact that a new name is ascribed to the federation. If there's an extension, then there should not be any amendment to the name of the federation. So I subscribe to the second interpretation that Sabah Sarawak, Federation of Malaya and Singapore form a new nation, and that is the Federation of Malaysia. Right.
Thank you.
Okay, that's my answer to that.
Would you like to share your view in respect of the two questions?
Asking me, all right. Yeah, I'm afraid I have slightly different perspective from YB here on this issue. The question was, is there a right to secede? The answer to that legally has to be, there is no right to secede. This is not a confederation. This is not European Union where Britain can leave. This is not ASEAN where you can leave. This is a federation. Neither in international law nor in constitutional law is there a right to secede. But YB is quite correct. Constitutions are evolving documents. If the federal government, which controls parliament, wishes to introduce an amendment like it did in 1965 to allow Sabah and Sarawak to go their own way, or one of them to go their own way, then of course there's no problem. But we are talking of a right. Sabah says we want to secede. I'm afraid that would be sedition under Section 3, Clause 1, Subclause B, Section 3, Clause 1, Subclause D, under the Sedition Act. It would be a criminal offense under the Penal Code. It's almost like waging war. There is no right to secede. Even in international law, is a colony or a self-governing territory has a right to self-determination. But once you have become part of a federation, then it has to be done with the consent of all parties. Singapore did not secede. Anyone who says that should look at the Constitution of Malaysia, how it was amended significantly by the then government to allow Singapore to leave. So I think the answer to the question, is there a right to secede? Of course not. Even if it's not in the Constitution, doesn't matter, it's in other laws. As to the second question, this is more, it's an impossible question to answer because it's a matter of perspective. Was it an extension of the federation or was it a new federation? You know, when the United States was formed, if I remember correctly, in the beginning, there were only 12 or 13 states. Now it is 50. One by one, later on, new states came on. And yet they retained the same name. They retained the same constitution with amendments. When in 1963, Sabah Sarawak federated with Malaya, and by the way, those are the words, federated with Malaya, found in MA63. When they federated with Malaya, the Malayan constitution with significant amendments was retained. So of course, it changed name from Constitution of the Federation of Malaya to the Constitution of the Federation of Malaysia. The head of the state remained the same. The prime minister remained the same. The seat in the United Nations remained the same with this change of name. So you could argue both ways. I personally have no strong feeling here. Territory-wise, I acknowledge Sabah Sarawak brought in 60% more territory. Their coastline is much bigger than the whole of West Malaya. So I can't really answer that question, Mr. Chairman. All that I can say is this, that there are countries which have worked both ways. So at one time, actually, Ireland was part of the United Kingdom. Then Ireland was allowed to go its own way. There was even a referendum in Scotland, but that referendum failed. So I agree, things can change, but there is no right. It has to be negotiated.
Thank you, Professor Shad. Okay, we have two participants here who has actually raised their hands, and we are allowing participants in this webinar to ask questions directly to the panelists. But I will invite both of them, but I will invite Mr. Reina Awang first. But before that, Professor Shad, before I forget, there is actually some requests whether it is okay for us to share your slides that you have presented just now.
Absolutely, sir. Absolutely. Whatever little I know, I'm happy to share. Though I have to say this, I would be revising my slides in the light of the learned comments from all the members, but by all means, please share.
Thank you, Professor.
Sorry, Mr. Chairman, cannot hear you.
Oh, sorry. Yes, sorry. Thank you, Professor Shad. Okay, I would like to invite Mr. Reina Awang to pose his question to any of the four panelists. Just that to remind all the participants to to pose a relevant question in respect of our webinar tonight. Thank you. Mr. Reina.
Yeah, thank you, Mr. Moderator. I would like to ask this question to Professor Shad. So this question is regarding the autonomy or devolution of power. So let's say the government of Sabah or Sarawak would like to have certain full autonomy over certain matters like education, or probably they say they want to take back the tourism to be put in the from the federal list to the state list. So is there any way the state government can do it through the state legislative assembly, or is there any provision in the federal constitution for them to do that, or is the federal parliament is the only way to do the amendments? Thank you.
Thank you, Mr. Reina. It's a wonderful question. And I will have to give my answer with some sadness. And that is this, that in 1963, when Sabah Sarawak leaders were negotiating with the leaders of Malaya, I think on this issue, they did not bargain well enough. The Sabah Sarawak Assembly have no say in constitutional amendments, even for those amendments which touch on the rights of Sabah Sarawak. The consent is that of the governor of Sarawak, not the Assembly of Sarawak. The only exception to that I know is this: if the territory of Sabah Sarawak is to be altered, then the Assembly comes into the picture. So in answer to your question, is there some way Sabah Sarawak could initiate a constitutional amendment? Well, it will have to be done in the federal parliament, either in the Dewan Negara, in the Dewan Rakyat, and it has to be done with the support of the federal government. It will require a 2/3 majority, plus of course, consent of the Yang di-Pertuan Agong and the Yang di-Pertuan Negeri Sabah Sarawak. So I'm sorry to give you an answer that is rather sad. There is no support in the constitution for participation. And may I draw I'll end there by give you an example. But in 1963, Sabah Sarawak, Singapore were coming in. Kelantan objected to that amendment. Kelantan said, you are going to convert a Malay country into a predominantly non-Malay country. You cannot do that. And Kelantan went to the court in the case of government of Kelantan versus the government of Malaya and Tunku Abdul Rahman Putra Al-Hajj. Kelantan objected and Kelantan lost. The court said, you have no right to object. Sorry.
Thank you, Professor Shad. Okay, I would like to invite now Leslie Kalong. Leslie Kalong to ask any question and or any of our panelists here. Yeah.
Yes. Yeah. Good evening. Can you hear me?
Yes.
Yes.
Yeah. I'd like to have a very short and straightforward question, especially for Professor Shad Salim and for Professor Bridget. Do you agree with me that there is no such thing as Sabah Sarawak is an equal partner as far as the Malaysian agreement is concerned? Because if we read through one single article in the Malaysian agreement, treaty number 10760, it mentioned here clearly that the government of the UK will take such steps as may be appropriate and available to them to secure the enactment by the Parliament of the United Kingdom of an act providing for the relinquishment as from Malaysia Day of her Britannic Majesty's sovereignty and jurisdiction in respect of North Borneo, Sarawak and Singapore, so that the said sovereignty and jurisdiction shall on such relinquishment vest in accordance with this agreement. Meaning to say, to be being very straightforward, it's clearly in the Article 4 in the Malaysian agreement, Her Majesty Queen relinquished her rights over Sabah and Sarawak and North Borneo to be transferred into a new federation which is called Federation of Malaysia. So do you agree with me that that article itself alone clearly proven that there's no such thing as Sabah Sarawak is an equal partner? And then my second question would be, do you agree with me that all this hoo-ha, all this trouble, all this, how do you call it, all this mess is created by politicians who only wanted to politicize things, but they failed to educate the younger generation of Sabah and Sarawak the truth and the right things about the Malaysian agreement? Thank you.
Thank you. Yes, I'll invite Professor Shad first to give his view.
Yeah, I myself in my presentation said that this idea of an equal partner with the states of the Federation of Malaya is more political talk. It has no legal basis. It has no historical basis. There's no such thing as an equal partner. In some areas, Sabah Sarawak are more than equal to all the other individual states. In some areas, they are suffering disadvantages. And I agree also with you, Leslie, that before September 16, 1963, Sabah and Sarawak were not independent sovereign states. They were perhaps self-governing, but they were not independent sovereign states. In much the same way, Malaya from 1955 to 1957 was self-governing. It had a legislative council. It was not a sovereign state. So I'm in line with you that there's a lot of politics here on both sides, by the way, on both sides, creating political myths and basically populism. A lot of it is populism. It's talk about equal partners, sovereign state. Sabah Sarawak are not states, but they are nations. The word nation actually in political science has a much different meaning. So I agree with you. This is a lot of politics. It has no legal basis. Thank you.
Thank you, Professor Shad. Dr. Bridget, do you have any views on in respect of the two questions that was posed? That yeah, yes.
I did mention in my talk that the notions of equality and the notions of partnership not only are political, but they're also not necessarily substantive. There are many political challenges in both of those areas. But I would like to pick up on the second part of Leslie's question, which has to deal with the issue of education, of how these issues are transmitted to the public. And I think that, you know, the discussions of MA63 are highly politicized, and there is no meaningful discussion of the different components within the curriculum of students or even in public discourse. You know, there is a need to increase literacy and awareness of the different sets of issues across segments of the society. And I think, you know, especially in Sabah and Sarawak, because these issues the substance of them mean so much, but they're talked about in a very superficial manner and often used as political tools, as opposed to talking about recalibrating relationships and addressing fundamental challenges and problems that Sabahans and Sarawakians are facing. And as I've indicated earlier in my early remarks, is that there is a need to increase scholarship, understanding, appreciation of cultural diversity across the board. And I think that includes within Sabah and Sarawak itself.
Thank you, Doctor. I have another question for you, Dr. Bridget. The Law Minister, Wan Junaidi, said that the proposed amendments were part of the government's commitment in fulfilling MA63, which had been agreed upon by Sabah and Sarawak. What is your view in respect of the way forward for Sabah Sarawak in relation with the federal government and states, way forward after this amendment? How do you see the way forward from all this?
I think there have been a number of important points made by the politicians in this panel about the need for a timeline, for the need for substantive areas of discussing decentralization in policy arenas such as health and education, to address the issues of cultural diversity. I think these are very substantive areas. It is my view that there needs to be a process of where leaders in Sabah and Sarawak can continue the discussion in a meaningful way to talk about how to contextualize and address some of the substantive inequalities that exist within the context of revenue development, as well as in the policy arenas of education and health and immigration. And I think there has to be some substantive arena that is not necessarily only in Parliament. And while there are these new divisions within the Prime Minister's office and there are some modest conversations taking place, I think these don't go far enough. And I also think the conversations are at very much at the high level and not shared publicly. And so the level of participation in the discussion needs to broaden and also to be engaged with more meaningfully in Sabah and Sarawak among the population and with political leaders, and in particular with the civil service who are implementing these policy areas. And I think if you begin to create avenues like this, you can actually deepen the discussion and also create a policy agendas that actually allow for traction, that don't become highly politically rhetorical, but also have more substance.
Thank you, Doctor. YB Chong, same questions. How do you see that a way forward for Sabah and Sarawak after the amendment?
The statement by Wan Junaidi, my view is that it is very worrying, as he sees that as a fulfillment. The word fulfillment is that we've done it already. It's the end, and we've reached the destination, the fulfillment, enlightenment. So these are our words. You see. So that's why I mentioned that there should be an amendment to further amendments to the Constitution, whereby this especially education and healthcare should be in the first stage to be put under concurrent list rather than exclusively federal list. In fact, I've spoken to Wan Junaidi on this matter on the personal basis. But what he was saying, is that there can always be devolution of executive powers, regardless, what the 9th schedule of the Constitution provides, which is federalism of power. The federal government can delegate the rights, the power to the state. But my question is that, at this juncture, at this point in time in our political landscape of Malaysia, right, the Sabah and Sarawak MPs are the so-called kingmakers that can tilt the balance of power at the federal level. And that's where you should make your demand quickly and within that window period, as what Professor Richard has said. You pass this window period, when after the 15th January election, you don't know what happened. If UMNO has a clear majority that they can form the government without the participation of Sabah and Sarawak, it will be reverting to what was previously in the pre-2008 era. Then we will expect the UMNOs returning to the way of governing at that time, and here our struggle for devolution of power, decentralization of power, all this will come to a stop. So the whole thing is that we should take this opportunity, since the Sabah Sarawak, the Perikatan Nasional or Barisan Nasional, their MPs, they form the numbers right? The kingmaker. So when you are a kingmaker, behave like a king, make your demands, and not sitting on it. So you see, the whole thing is that what Junaidi has mentioned about delegation of executive power, that can be changed anytime. When politically Sarawak and Sabah do not hold the leverage, then I think that delegation of executive power may go back to the federal government. So that is why we have the constitution to entrench our rights. And this is the golden opportunity when the federal government on the Semenanjung side is weak. That is when Sabah and Sarawak, the state government should make the demand for constitutional amendment to safeguard or even enhance the rights of Sabah and Sarawak. And you know, we regardless who make the proposal, we as a Sarawakian MPs, I think we will not only support, but we will persuade our colleagues from the Semenanjung to support. And that's what we see, a unanimous approval of the constitution amendment in last December. But the same does not go when we as Pakatan Harapan, we presented the amendment to the constitution. Although we all know that it is a symbolic, number one. Number two is the first step to the decentralization or to the implementation of the spirit of MA63. That was the first step, but it was rejected at that time. Is it so? So what I foresee now, how I like to see in the next few months will be one constitutional amendment after another constitutional amendment. There should be a timeline set, like what I said in the beginning of this seminar. That one after another, gearing towards or implementing the devolution and decentralization of power. And this window opportunity is closing in very quickly because we never know when is the next federal election. Probably after July or even sooner. So my to respond to your question, how do I see Junaidi's statement? I think it seems to have achieved its purpose, and this is the fulfillment, and that's it. But I would like we will push further. I mean, we always believe in decentralization of power. There should not be over centralization of power in the federal government. So we will continue. I'll continue to push both in Parliament and in Dun Sarawak to have a timeline set for every steps to be taken for towards this decentralization of power. All right.
Thank you, YB Chong. Okay, I have a question for YBDSP, Dr. Wilfred Madius. We have read your views on this, that you believe that the IGC should be revisited, but with the latest views given by Professor Shad in this webinar, where he had said that the IGC report has been constitutionalized also together with MA63. So do you believe, sir, that there is still a need for IGC report to be revisited, even after taking the view of Professor Shad?
Yes, IGC is the Intergovernmental Committee report. It's the report that which is the outcome of meetings from the President of Malaya, from Sabah, Sarawak, and this and that, and that this is how the nation should be administered. I would say that the 20 points memorandum, the IGC is the legal version of that, I suppose. Yeah. Takes, for example, like Borneoization. Professor Saad mentioned about the lack of the inability for the government to recognize that and to implement that. So there's a one. How do we actually recognize? How do we actually implement Borneoization? How do you implement issues like freedom of religion, for instance, it is there, it's getting out of hand now, talking about, Sharia, talking about, Kalima Allah, things like that, we need to review this, we need to come back and sit down and look at this, and if we need to make changes, yes, perhaps the motion that I and YB Chong proposed in Parliament during the amendment of this particular amendment to the Constitution, we can bring it up there, in the review of the IGC. We can review it there. Should education and health be put in the concurrent list? Okay, let's talk about it. Yeah. Okay, let's talk about tourism, for instance. Okay, and then of course there are so many issues that we can talk about. Yeah, and for us, of course, for Sabah and Sarawak, for Sabah, as I mentioned earlier, it's a very clear entitlement, 40%. Okay, how do you implement that? I see the IGC as something and an area where we can actually implement. Yeah, and then the other part, of course, is which part of this amendment is the recognition of the birthday of Malaysia, 16 September. Okay, the commencement date of this country eventually recognized after more than 50 years, almost 60 years. Okay, now how do you actually recognize this? How do you give meaning to the birthday of Malaysia? Okay, we have been saying this in Parliament, for instance, that okay, when we celebrate this birthday, it should be celebrated by the nation and not just in Sabah and Sarawak. And surprisingly, even other colleagues in Peninsular Malaysia, that's yours, it's not ours. As if Malaysia belongs to Sabah and Sarawak only, And so we have been saying that we should celebrate that in Peninsular Malaysia, and perhaps, in national capital, Kuala Lumpur, Putrajaya, things like that. And perhaps then this will serve as a process of education for civil servant, even political leaders in Peninsular Malaysia, that the Malaysia that we have formed is not the Malaysia that have gone into their minds, Yeah, so perhaps this is it. And then slowly, as Bridget had mentioned, it should go into the curriculum. Rewrite, improve on in our history books and things like that, So that is, to me, some of those that are very important, And I have asked this in Parliament during the debate, and there is no answer. They simply refuse to answer. Even Tan Sri Anwar Musa, who is the chairman of the Malaysia Day celebration, I said, "Are you going to consider to celebrate Malaysia Day in Putrajaya in Kuala Lumpur next year?" There's no answer. He didn't answer. Even the Prime Minister didn't answer. So these are really telling what we call this mindset, in the leadership, that you have not actually recognized and you have not actually acknowledged what Malaysia is to all of us, and therefore then you are stopping here, you're just appeasing us that okay, now you have amended, we have put it back to 1976 and that's it, and to us, no, it's not. So that's why, to me, this amendment is significant, especially on Article 161 on the commencement of Malaysia, that now that you have it, let's celebrate it, let's implement it as the way it was, as we have agreed in 1963. Thank you.
Mr. Moderator, maybe let me just to clarify one point. Yeah, sorry to touch on that. When I talk about this devolution of power in decentralization of power in this healthcare and education, it is not so much of the spirit of or the provision in the MA63 that because pursuant to MA63 that we are talking about devolution of power, but the devolution of power I see as a practical need and that will serve the goods of the benefit of people in Sabah and Sarawak, and also it may improve our efficiency and diversity in our country. So that is why I'm very passionate about this agenda of decentralization of power in the areas of education and healthcare. Not because it was in the MA63. I do believe that under the MA63, education and healthcare was intended to be federal power under federal jurisdiction. It was then, 57 years ago. But now I think the situation has, over the last half a century, is proven that this centralization of power in these two areas doesn't really work that well, number one. Number two, there are a lot of inefficiency that has come a long way, more because of we are divided in by the South China Sea. So that is why I see that, for more efficient implementation of policies in these two fields, that we should have a devolution of power in healthcare and education. And my push for that is based on practicality and actual benefit for the people, not because of the historical or legal implication of MA63. Not because of that, but actually on the practical consideration. All right, that's just to make myself clear, because there's nothing mentioned about that. There's nothing mentioned in. I don't think there's anything mentioned in MA63 that health and education should be state power. I think it was intended that it should be federal power, federal within the federal list. All right. Thank you, Mr. Moderator.
Thank you, YB. We have one more question here from Mr. Richard Barrow. I would like to pose this question to either Professor Shad and Dr. Bridget. Okay, the question is, the IGC report was agreed over 54 years ago, when there were few experts in many fields in the Borneo states. Now, all these years later, times have changed. Surely, we now have unlimited experts in Borneo. Should we not move on and change was used to be state, federal, and concurrent list? So I would invite Professor Shad first to give his view on this.
I totally agree that times have changed. A constitution actually is a voyage and not a harbor. It's something that has to grow with the times. It has to recognize the felt necessities of the times. And actually, sorry, I was not able to clarify this point adequately because of problems of time. I'm not in any way suggesting that just because there is some recognition of MA63 and indirectly of IGC, therefore nothing needs to be done. What my aim is to point out that Sabah Sarawak advocates, and not necessarily the advocates come from Sabah Sarawak. I'm a Sabah Sarawak advocate also, I think. I think we should point out, first of all, that the existing provisions of the Federal Constitution of 1963 have not been implemented in many parts. Why is that so? So as pointed out just now, on issues of Borneoization, things are not taking place. On Article 153, special position of the natives of Sabah Sarawak, things have not worked out well, 40%. So first of all, we should know what the Constitution already gives. Secondly, we should look at some of the constitutional amendments that repealed many of these rights, and there should be effort to restore those rights, restore those guarantees, for example, on the issue of Islamization. Thirdly, and I totally agree that there are new issues of devolution that need to be looked into. 58 years is a long time in the life of a nation. And I think on many, many issues, there's need for new thinking from the point of view of functionalism, what will work best. After all, the federal government has been making so many changes. Federal territory was created out of Selangor. Putrajaya was created out of Selangor. Federal government took tourism away from the states, put it in the federal list. So I think it should be a two-way process. Just like some state powers were transferred to the federal government, in some respects, it's necessary today, in the light of the exigencies of the times, that some federal powers should be transferred to the state list or concurrent list. I personally do not like the idea of concurrent list, because concurrent list means both can pass a law. And may I alert you, there is an Article 75, which says if there are two laws on a same point, one federal, one state, then the federal law will prevail. So it's not safe for you to go for a concurrent list, go for the state list. So I agree, yes, Richard, IGC report needs to be looked into. For that matter, the Constitution needs to be looked into. The Constitution is also 58 years old. But there is a lot of significance to pointing out that, look, it's there in the Constitution. Why are you not enforcing? They cannot therefore say, oh, it's uneconomic, or it's in the Constitution. You have to abide by it. This Constitution is the supreme law of the Federation. But in addition to that, new issues of devolution need to be looked into indeed. Thank you.
Thank you, Professor Shad. Okay, it's almost 9:50 now. I was told that we should take a group photo first before we continue until 10 o'clock. So I would like to invite all the participants to switch on your video so that we can take a big group photo for this webinar. Thank you so much. So over to you, Frida, for this photo session.
Sorry, but I believe my laptop is unable to do it at the moment. Could Kat take over?
Yeah. So I will be taking the photo. So let's wait a while. Okay. I will take the photo now. So 1, 2, 3. Okay, another page. Just 1 second. Another time. 1, 2, 3. Okay. Yeah, thank you.
Thank you so much. Okay, so thank you for all the questions that was asked by our participants here. I have to apologize because it's already 9:50, and I would like to invite each of our panelists to give their summary in respect of the webinar tonight. Maybe I'll give about 1 to 2 minutes for each of the panelists to have their final say in respect of our webinar tonight. So I would like first invite Professor Shad, maybe 1 or 2 minutes, sir. Thank you. You're muted, sir. Yeah.
Thank you very much, Mr. Chairman. I will simply say this, that I think this amendment is a good beginning, and I'm entirely in agreement that it should not be regarded as an end, should not be regarded as a simple symbolic case of appeasement. What is very important is for Sabah Sarawak to strike the iron while it is hot. I did mention this, many others also acknowledge that politically Sabah Sarawak have gained tremendous importance because of the politics of the nation. The 56 MPs that Sabah Sarawak have together constitute 50% of 112. 112 is that magic number to form the government. 50% of that come from Sabah Sarawak, can come from Sabah Sarawak. I think this is the time for Sabah Sarawak to push their cases through. A very important point that came up was this. I think Sabah Sarawak need to cooperate with each other, even though their jural postulates are different, their imperatives are different. Nevertheless, on this issue, they should cooperate with each other. Thank you.
Thank you, Professor Shad. I would now invite Dr. Bridget.
Thank you. I would say just a few things to add to the earlier comments is that I think that the discussions need to move away just from the legal discussions to addressing some of the fundamental grievances and the problems on the grounds for Sabah and Sarawakians. And this means in the areas of development, education, health. I think these are things that need greater attention and meaningful discussion and recognition. I think I've reiterated across this discussion from my point of view that a lot of the problems continue to lie within Peninsular Malaysia. You need to change, to create greater awareness, to promote more understanding and discussions. And until you fundamentally change mindsets, you're not going to be able to have significant traction moving ahead. And the third thing I've emphasized is the need to have to take opportunities that are substantive out of this constitutional discussion, which at this point in many ways still remains largely an appeasement process, not necessarily one that has enough traction. There needs to be opportunism on the part of Sabah and Sarawakians, not just political elites, but others, to try to make these dimensions of greater autonomy more robust and more substantive. And I'll stop there.
Thank you, Doctor. I'll now invite YB Chong.
Yeah, I have unmuted. Yeah, I think for me, I love to see more devolution of power to the state, but one thing that please not be mistaken. I think many will see that this devolution of power to the state will be a panacea to all the woes that the Sarawakians have been suffering all this while, but that is not the case. Right? There are a lot of matters which lies in the absolute power of the states, and that was not handled properly as well. Our timber resources, our land issues, all these are. So I think while we are talking about this devolution of power, more importantly, I think for us Sarawakians as a whole, I think we should be more politically aware, not only in respect of this federal-state relationship, but also about good governance, check and balance, and a more transparent and accountable system of governing. That would be the solution to a lot of the problems to our state. It is not about the federal has taken too much power, and that's why we are we are in such a poor, pathetic state of the affair. But it is actually, I think, the lack of good governance, transparency that we should equally emphasize on, in addition to this devolution of power. So there should be a two-pronged education of the public in matters of this public governance. Yeah, that's I think my conclusion for the whole matter.
Thank you, YB Chong.
Yeah.
Now I would like to invite our last panelist, Yang Berhormat DSP Madi Stangau, for his conclusion on our webinar tonight. Datuk Sri.
Yeah, I've always believed that we have to go beyond the legal part of the whole MA63, and we have to go beyond rhetoric. There have been a lot of rhetoric. Also those who make use of MA63 for political purposes rather than going into the substance. So the more people talk about this, especially those who talk about it in a substantial way, I think we should encourage this, and we will continue to open a venue, provide a venue, platform for people to talk about this. And for parliamentarians, I think we, across the political divide, we should come together and continue to pursue this, in parliament, so that it will not stop in here, that this is a new beginning for us. Okay, when we talk about decentralization, let's pursue this, let's pursue this as a parliamentarian. And sometime when the opposition talk about this, some others will see it as some political, what we call from the political angle. But we will do better if we work together. We work together, the opposition as well as the government. Okay, we now have the opportunity that the issues of Sabah and Sarawak, for instance, is being given a unit in the Prime Minister's Department. Let's work together, and make it happen there. Okay. If in the past you talk about lots of hope on the 40%, I think perhaps there are work that can be done in there. We have to go beyond Sabah and Sarawak. We have to go and talk to our friends from the other states, and we need their support, from the other state to what we want, and we need to talk to even civil servant, create awareness from them, so that we could see it happening. And finally, once again, I want to say that the IGC 2.0 should happen. And now we talk about the MA63 review. It's being done and things like that, but we should really review the IGC. We should really review that. We should look at how it has been implemented and what else can we do. And if we need to strengthen some of those in the constitution, and then let's do it. Yeah. Other than that, some of those points that was mentioned by Professor Saad, things that has been done before, I think need to be corrected. For instance, on Article 122, the judicial, we call the power of
to appoint judicial commissioner in Sabah.
Appointment of judicial commissioner, I think that has to be done. We have mentioned that several times in Parliament. The amendment to 1994 that should be restored. Again, I at my level I have spoken to Wan Junaidi on this. That this has to be done, and I said it has to be done during your time. He is a Sarawakian de facto law minister, and we have Max, who is in charge of the Sabah and Sarawak unit. And if they fail to do this, then who else can do this? It will never happen again. We should restore whatever, in the way that Article 1, 2 was restored, and so the Article 1 to 2 should be restored in the way that it was done, and others. Yeah. So that's it, Nelson. I think that I have to say. I think we're going to pick some of these points that was mentioned by the panelists tonight for more awareness. I like, for instance, like when Bridget mentioned that this should not be the end, this should be the beginning. Yes, let's take it from here and subject it to more public discussion in the way that we are doing it tonight. Thank you.
Thank you, DSP. Yes, I think we are at the end of our webinar. I would like, on behalf of Wisdom Foundation, to thank everyone for still being with us since the beginning until now. Also, that as a conclusion, for me, it is quite enlightening and encouraging, the views from Professor Shad, where what is important, I believe, is that his view that MA63 and IGC has now been constitutionalized through this amendment. So I think there's a lot of work for our elected representative, our lawmakers, YB Chong Chin Jen and DSP Madius Tangau. As Dr. Bridget said, that is only the beginning. So I believe there's a lot of other amendments that needed to be done. As Professor Shad said, there are 80 over provision that needs to be resurrected. So, so I believe through the webinar tonight, I believe a lot of new points that has been raised, shared, and I think this would be a start of Sabah Sarawak to ensure of getting our rights as enshrined in MA63. That is from us. That is all from me and from us. Again in our next webinar, which we will announce soon in our FB page. Again, on behalf of Wisdom Foundation, thank you to all our panelists for spending about 2 hours with us tonight and answering all the questions that has been posed. Again, thank you for all the participants. Good night.
Good night.
Good night.